We talk a lot about the United States Supreme Court. There's been 13 different emergency applications just by the Trump administration alone in the first 110 days. But would you believe the first oral argument involving a Trump policy and an appeal is just this week? It's just going to be on Thursday, the 15th of May at 10 a.m. You're going to want to be here on Legal AF. We're going to be doing a special live feed, a pregame show and a postgame show. I'm going to be in the live chat. You're not going to want to miss this. We've done a number of live oral argument feeds directly from the United States Supreme Court, but we'll add to it. We'll do the value add of our commentary. And on a show we do weekly called Unprecedented, also here on Legal AF, Dina and me, we got together. We talked about what's at stake. How are the issues framed at this United States Supreme Court oral argument? It's really about nationwide injunctions and whether federal judges can issue them, what we call universal injunctions. But it's coming up through the Birthright Citizenship case about the 14th Amendment right to be an American and Donald Trump trying to take away that right by way of an executive order. All comes together. We talk about it on Unprecedented, and here's a clip.
But I'm so excited to be doing the live on Thursday because you can get so much out of listening to the live. We're going to get a really good sense of where the Supreme Court is going to go. And this is the first time the Supreme Court is finally looking at the substance of something. This isn't just procedural. Everything else the Supreme Court has done has been like a procedural decision. And when I do the hot take before, I'm going to lay out for everybody exactly what the essential question is. I'm also going to give you a little bit of a preview of, like, for example, Justice Gorsuch has always wanted the court to look at this issue. Even back in January, the court had a chance to look at nationwide injunctions and they decided not to. Justice Gorsuch did a separate opinion at the time saying this was our chance. So anyway, I'll try to give as much as possible a background from what we know about the justices in terms of ever talking about birthright citizenship or nationwide injunctions. So that way everyone goes into listening to the live a little bit more informed. And then it'll be fun to do the post analysis with you. You're lucky on the East Coast. It's not going to be that early for you.
I'm going
to have to wake myself up.
It's usually 10 a.m. and they usually take the bench around.
Oh, that's not too bad. Okay, for some reason I thought it was 9. Okay.
We have to check. I'm going to check the schedule. To check. We're going to announce it. People, if you haven't already, subscribe to Legal AF. You'll get and set your reminders. You'll get a reminder when we post the live version, and you can hang out there and chat with us. I'll chat during it, and I'll get the exact time and we'll announce it in the future. Why don't we lead right there? Why don't you talk to the audience about this nationwide injunction and the underlying birthright citizenship? Because it's hard to believe there's been so many emergency applications to the United States Supreme Court, but this is like the first oral argument about a Trump policy in a non-emergency application method. So a real oral argument. We've had oral arguments that we've covered, but they really were about positions taken in the past in cases that were kicking around for a couple of years, even before the Trump administration. This one has got Trump's fingerprints all over it, and it's really the first one. Why don't you preview what we think the arguments are, and then we can kibitz a little bit about the case.
Yeah, I mean, I think that we're going to hear kind of a repeat of what we've been hearing on social media about nationwide injunctions are being abused. They're going to say they're being used too much. Here's the situation. Nationwide injunctions are a little bit complicated, right? Even for us lawyers, because on the one hand, when they're used against us by Trump and they go and they find that one Texas judge who's going to make it illegal for the entire country to use the abortion pill, we don't like it that much. But when it's done to stop Elon Musk from going in there and getting access to our social security information, we like it. So it is a little bit, should one judge have the power to decide federal law throughout the country? It is a good question to ask. There's nothing wrong with asking that question. The problem is let's say they did away with nationwide injunction. Then the idea that we could have children here in California who are citizens, and you could have children in Florida who are not citizens, seems like a complete violation of due process. How could you? The idea is it's federal law, not state law. everybody in the country should be having their federal law applied equally, right? So that's the counter argument for why one federal judge should decide decide for the entire country. Again, it's also just an injunction. It's not permanent, right? It's a matter of, for now, this is the law for everybody for now. So it is going to be an interesting, I think, a very interesting, like intellectual or philosophical argument. I think that the reason why the Supreme Court didn't take it up in January is there's no easy answer to it. And that's why they didn't really want to delve into it. It's even if they think that they don't like one judge to have this much power, them coming up with an alternative that's workable is going to be really tough. So I could see in a way the discussion maybe getting moved forward, but I don't see there being like a complete flip in how it is done now, because of the fact that them coming up. I mean, this is what we saw with gerrymandering, right? The Supreme Court has had a hard time stepping in and they have done it, right, in the case of Alabama, but most times they don't, because they said, we cannot come up with a workable standard. It's very important to them to come up with a workable standard, because they're basically giving direction to all these judges in the country. How are you supposed to handle a situation like this? So to me, coming up with a workable standard is what is going to be difficult, even if they wanted to change it. So I think that's where the argument's going to go.
Yeah, I agree with you. I mean, you have some of the Supreme Court justices have been very adamant about what they see as the overuse of the nationwide injunction, Gorsuch, as we talked about. But others, I think, recognize that it's not one size fits all. You have to give the flexibility to federal judges to fashion a remedy, and sometimes the remedy, in order to make any sense, has to be nationwide. Mm-hmm. I mean, even when they were banning mifepristone for medication abortions, I mean, he issued a nationwide injunction stopping women for a period until that was vacated, stopping women from using that nationwide as opposed to like state by state, And how can you have somebody in Louisiana who has a baby is not going to be a U.S. citizen, but somebody in New York is? It's bizarre. Mm-hmm. But, Trump is always trying to press his advantage, and he's trying to pressurize the Supreme Court and stampede the Supreme Court into making these kind of decisions, and using this this would not have been my vehicle to try to challenge nationwide injunctions, but they were like, well, all right, let's use this one and see what happens. So, we're going to know early on. The one thing about oral arguments, to give a little bit of a primer, the one thing about oral arguments, especially at the Supreme Court, is you kind of know early on where the that's why you'll often see headlines, skeptical court, conservative majority, or unified position seems to be coalescing around. It's because sometimes minds are changed after an oral argument. I mean, the reason for oral argument is supposed to be they've read the briefs, they've read all the briefs, they've read the amicus briefs and the parties' briefs and the friends of the court briefs and all of that, and now they've got some questions. So when you're an advocate, and I've done appellate advocacy, just not at the United States Supreme Court level, you got to be prepared. You come up there with a little script, because sometimes, depending upon the bench, they won't ask you many questions at the very beginning, but so you got to have something sort of prepared so you can talk eloquently about your case. But at some point on a hot bench, within 2.5 minutes, it's like, well, let's forget all your briefing. Let me ask you a pointed question. Follow me on this example. And then it starts. It's called a hot bench, right? Because all the judges are jumping in, and let me pick up with what Judge Sotomayor just said. But your example to Justice Kagan, and then you're off and running. And you got to just keep, as an advocate, you got to just keep a North Star to navigate by, to make sure you're hitting your points. You have to answer their question, but you also have to make your argument. And that's something that more junior appellate advocates don't understand. You can't just it's not a tennis match. It can't be a tennis match where the Supreme Court justices just run you ragged around the court, left, right. Now, you have a strategy. You need to present your argument. You need to do it through but if you have 4 points you got to make, You got to figure out how to answer their question, pivot, and get to one of your 4 points in the time allotted. And that's why there's an art to oral advocacy, especially at the United States Supreme Court, because you don't see them going. Occasionally, they'll be like, "Well, there's a dispositive case." We're beyond dispositive cases,
Right.
here, right? We're up to.
Doesn't matter as much.
It doesn't matter as much at the Supreme Court. They're making the law now. You can say, "Well, the leading case in the area," but everybody in that room knows the leading case. It's like a magician. It's like a magician on a stage in front of a room full of other magicians.
Yes.
Right?
I think the last oral argument that one of the lawyers was trying to tell Justice Sotomayor, like what their court held, right? In a prior opinion. I was like, okay, good luck with that, buddy.
It's a whole nother world. At a lower court, you can, when I've advocated in front of a trial judge or even a lower appellate court, sometimes you get it more into the nitty gritty. There, it's much more esoteric. It's much more academic. If you're on a motorcycle in the trial court level, you're in an airplane at 20,000 feet at a Supreme Court level. And so that's why, I think our color commentary before and after and during, I'll be in the chat with you, will be so helpful to that. Welcome back. We sit at the intersection of law and politics so that you don't have to. We here on Legal AF are experts on constitutional law and as practitioners and oral advocates who have been in front of appellate courts, just like the ones that we talk about. And we're glad you're here with us on Legal AF. Take a moment, hit that subscribe button with your thumb or your finger, and come back every week for Unprecedented with Dina and me, Michael Popok. So until our next report, I'm Michael Popok. I'm Michael Popok, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touches Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popok Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popok Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popok Firm today at 1-877-POPOK-AF or by visiting my website at www.thepopokfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popok Firm, fighting for your justice every step of the way.